This is Newsnight. A warm welcome to you. I'm Iman Rapetti. It's just after 7 o'clock. Prosecution's boss, Sean Abrams, has placed his deputy and another senior official on special leave. Deputy Director of Public Prosecutions, Nomgcobo Jiba, and Executive Lawrence Mkhwebi, both asked to be put on special leave. That's after they were struck off the roll of advocates yesterday. The judgment by the North Gauteng High Court followed a complaint to the General Counsel of the Bar. Concerns were raised over how they handled 3 politically sensitive cases. Both Jiba and Mkhwebi plan to appeal the judgment, which effectively blocks them from working for the NPA. Let's talk now to Nomgcobo Jiba's lawyer, Zola Majavu, who joins us via Skype. Good evening to you and welcome. Thank you very much for your time. Why did your client ask for special leave?
It's important to state that she has elected to exercise her appeal rights. As matters stand, we are under instructions to bring an application for leave to appeal, which we are hoping to file by no later than end of next week. She has 14 days within which to do so. Obviously, if we do that, that exercise has the effect of suspending the order of yesterday. But now coming to why has she decided to ask for special leave? We had constructive engagement for the better part of this morning. And she, on her own volition, decided that it would be best, given the public interest nature of this matter, the office she occupies, to allow this process to unfold without her being in office. And she decided to ask the NDPP to consider placing her on special leave. That request was acceded to about 2 hours ago. And as I'm talking to you now, she has been granted permission to go on special leave.
Were there discussions earlier, Zola Majavu? We spoke to the Justice Minister yesterday, Mike Masuta, who said that there would be discussions today with the NDPP. There would be discussions about what to do in the aftermath of the North Gauteng High Court's ruling. Did those discussions take place? And did the President have any part in this conversation?
Not that I am aware of. However, I am aware of a discussion that took place between my client together with our legal team, as well as the NDPP. We are still aware that the minister intends to engage in further line, and perhaps so should the president. But we thought it would be prudent not to put everybody under pressure, and the step that my client decided to do might have already, neutralized the need to meet on an urgent basis, because the fact of the matter is she will not be in office while she ventilates her appeal processes. But yes, we remain open to engaging with the Minister of Justice as well as the President to the extent that there may be a need to do so, while my client's rights remain fully reserved.
What are the other provisions of the special leave arrangement, Zola Majavu?
I'm not at liberty to discuss those, other than to say that she would effectively not be in active duty. However, all her other labor law rights would remain intact.
On a personal note, the judge in the North Gauteng High Court was particularly scathing, talking about both Mkhwebi and your client. They should have stood firm and vigorous. They flouted every rule in the book. There were a number of things that he said, basically also saying how could they stoop so low as to not do the right thing insofar as Richard Mdluli is concerned. It was a particularly scathing judgment. What was your client, how did she internalize it? What was her reaction to that finding by the court?
Firstly, she respects the court's finding, and it is not her place to criticize the courts publicly. However, she is aggrieved by some of those findings, and it is precisely for that reason that she has elected to ventilate it further in the appellate courts. She clearly does not agree with the take of the court, and at the risk of sounding contemptuous, she has instructed us to challenge those particular aspects of the ruling that she feels offended about. Whether or not she will be vindicated is another story, but we do accept the fact that the judges made their decision on the material before them. They interpreted it the way they did. There's a chance that another panel of judges may see it differently. Let me hasten to say, she was criticized originally on 3 counts. And on the 2 other counts, the very same judges took a view different to the other judges that criticized her. And they were of the view that her actions were not irrational and, in fact, did not even warrant a striking off or a finding that she is unfit and proper. So that already indicates to you that at the end of the day, it's a matter of interpretation on the same material that each judge or judges consider.
There's been a great deal of attention ascribed to developments in this case, Mr. Majavu. You'll concede a lot of legal analysis in the aftermath of yesterday's judgment, talk about defense lawyers who might have lost cases under both Mkhwebi and your client's watch, that there is potential here and scope for review. You talk about going back to court and asking for leave to appeal a full bench of the SCA judges, and of course you're within your right to do so. But in your advisory role for your client, have you for a moment given guidance to perhaps desist from going further, that this might harm her reputation and her case even more, might go against what the President requested earlier today, the saving of South Africa's reputation, that in fact to go along this path is to do more damage specifically to her reputation?
Firstly, it is difficult to go on the whim and the say-so of various legal analysts. I am one myself. And obviously, whatever the perception may be, does not trump her constitutional rights. She remains a citizen of this country who should enjoy the same protection that you and I enjoy. There are other office bearers who have been criticized, who are facing charges, but who are allowed to go on in their duties. Even if I had discussed whatever advice I gave to her, I would be silly as a lawyer to discuss publicly what my advice to my client may have been, other than to say, as a lawyer, I'm a creation of my client's instructions. As matters stands, my instructions are to ventilate the appeal processes, as she is perfectly entitled to do so. I find it very strange that nobody is commending her for the step that she took on her own volition to say, while all of these processes are unfolding, respecting the integrity of the office that I occupy, I am prepared to step aside. When in law, there is nothing that would have forced her to do so. But be that as it may, we also appreciate that she occupies a very senior position, a very important position in a very important arm of the state. And it is for that reason that people are welcome to raise their views. And those views should not be elevated to a point where she should now not be allowed to ventilate her processes. It would not be fair.
I'll just ask for your professional assessment on this one, Zola Majavu. The NDPP statement talks about the pair of them as advocates, and of course we have the judgment yesterday that they be struck off the roll. In the interim, is there a holding pattern, and are they correctly ascribed those titles, or do they cede that as of yesterday, just by way of technical explanation?
Fair enough. It's a fair question, and I appreciate it. Remember, that same decision of yesterday is not necessarily effective immediately, because my client certainly has 14 days within which to exercise her appeal right. If she does so, it means the decision of yesterday itself then is put on ice until all the appeal processes have been ventilated. So yes, according to the court order yesterday, their names are struck off the roll. But remember, if they avail themselves to the appeal right, that particular same decision is itself placed on hold. So technically, yes, they can still be referred to as advocates for the next 14 days and beyond, depending on whether or not leave to appeal is granted or whether the petition is successful. But bottom line is, respecting the court order, the court said their names should be struck off. But remember, that is the court of first instance. It may well be that when the matter proceeds further, that decision may be overturned or it may not be overturned. It may well be that this matter might go all the way to the Concord. And until all of those processes have been ventilated, I do not think it will be fair to say they need necessarily to be stripped of that title. My client has no appetite to continue to be called advocate. However, she has instructed me that she will abide by the rule of law and subject herself to all the processes. And it is precisely for that reason that she decided, look, I'm going to step aside, and I'm only speaking for her. And I'm pleased to note that her colleague has also taken that view by putting country first and saying, look, let's allow the due process to unfold, respect the space of the public to express their opinions, but the public must similarly respect their rights to ventilate these issues.
All right.
If needs be, all the way to the Concord. However, my client is really open to persuasion. And
we'll leave it there. We'll leave it there, Zola Majavu. Thank you very much for your time. We do appreciate it. That was Zola Majavu, Nomgcobo Jiba's lawyer.